Hi, everyone. We are talking about Young versus United Parcel Service today. I'm Adam Talmadge.
I'm Danny Viss.
I'm Andrew Wright.
And I'm Cody Travis.
So, moving on to the next slide, we will be talking about the table of contents. So, at first, we're going to talk about the summary of the case, the decision, and the concurrence and dissonance of what happened. We will also implement a legal tie-in of the case and then ethical implications.
So, to begin with, the summary, a woman named Peggy Young was employed as a part time delivery driver for United Parcel Services, otherwise known as UPS. And basically, her responsibilities included pickup and delivery of packages that had arrived by air carrier the previous night. And so in 2006, Young requested a leave of absence for in vitro fertilization and became pregnant. Doctors advised her not to lift more than 20 pounds, I believe it was for the first 20 weeks, and then no more than 10 pounds for the following. UPS employee policy requires their employees to be able to lift up to 70 pounds. Young could not fulfill the work requirement and had already used all of her available leave. UPS forced Young to take an extended unpaid leave of absence. Young lost medical coverage over this period, and after she gave birth in April 2007, she began working for UPS again shortly after. She sued UPS, claiming she had been the victim of gender and disability-based discrimination under the Americans with Disability Act and the Pregnancy Discrimination Act. She claimed that UPS acted unlawfully in refusing to accommodate. She had claimed other workers with similar situations were accommodated for.
Okay, so now to get into the Supreme Court's decision. There was a 6-3 decision in favor of Young. The majority opinion was made by Stephen G. Breyer, and the courts must determine whether there are legitimate reasons for differences in an employer's policy that treats pregnant workers less favorably than non-pregnant workers with similar inabilities to work. So as I said, the court ruled in favor of Young versus UPS 6-3. The Supreme Court did not accept the broadest version of Young's argument, but getting into further detail, they realized that she was actually incapable of doing the services that UPS demanded of her. And basically what the judges came to, in a sense, was that they made it clear that nobody can be treated the way that she was by an employer. And the Pregnancy Discrimination Act amended Title VII of the Civil Rights Act of 1964.
So, moving into the legal tie-in of the case. So, going back to that Civil Rights Act of 1964, including that Pregnancy Discrimination Act within that. So Title VII prohibits like the sex discrimination, and because of the basis of her being pregnant in childbirth and other medical conditions that cause you from not being able to be discriminated against. So women affected by pregnancy, the same for all other employees. They're not affected in similar ways, and as in fact their inability to work. So it's kind of just involving that discrimination aspect and how women, and in particular pregnant women, should not be discriminated against in activities that they perform. So talking about the American Disabilities Act of 1990, pretty much Young said that UPS discriminated against her because she was a pregnant worker and because some other workers that weren't pregnant but were hurt on the job were given this light duty for injury policy, which UPS did not have proper accommodations for women who were pregnant not to lift more than 20 pounds or anything like that. But this light duty for injury just specifically had to do with workers who were injured on the job and could not perform their functions. So she was arguing that it was going to be the same thing and it should be the same thing for her. This relates to chapter 17 in our textbook, and it actually showed that UPS coincides with the coverage and applicability of FMLA. So pretty much like FMLA requires companies with over 50 employees to provide 12 weeks of unpaid leave to take care of themselves, a child, or a parent suffering from a medical condition anytime during a 12-month period. So UPS has obviously more than 50 employees. They had 434,000 employees as of 2016. And since Young was taking care of herself and her inability to lift more than 20 pounds with her being pregnant, UPS was allowed to give her 12 weeks of unpaid leave, which they did correctly. But Young claimed that she was still discriminated against by UPS by not having that proper accommodations for the pregnant workers. So that was the main thing going into Chapter 17, the legal tie-in.
Well, I don't know how to go after that, but looking at the ethical issues, obviously we talked about the summary of the case, the legal tie-ins, and the decision. Now let's just kind of take a step back and look at the ethical issues raised. And ultimately, it was a discrimination against PDA, but the ethical part of it is that they didn't have the right accommodations for her. UPS responded, this is not in the article, that they have accommodated 1, drivers who have become disabled on the job, 2, who have lost their Department of Transportation certification, and 3, those who have suffered from a disability covered under the Americas with Disability Act of 1990. So that was the issue she was raising, was that they were not accommodating pregnant workers. Clear case. One of the things I pulled was the quote was, whether and in what circumstances an employer that provides work accommodations to non-pregnant employees with work limitations must provide work accommodations to pregnant employees. Ultimately, this quote is saying that there was no accommodations for pregnant employees. And then looking at Stephen Breyer's, as we talked about the majority opinion, he stated, whether the nature of the employee's policy and the way in which it burdens pregnant women shows that the employer has engaged in intentional discrimination. So ultimately, this is a discrimination case that she is trying to bring out the ethical dilemma in. As we previously stated, just to kind of wrap up, it was related to the PDA and the Americas with Disability Act, but it also was really trying to call for clarity regarding the Pregnant Workers Fairness Act. And that was something that she was trying to bring into light. And one quote I pulled was from the Supreme Court, how it believes a most favored nation is a nation with total equality. And we talked about how Talmadge was saying how someone at work got hurt and they got compensation. They got, the 12 weeks off, whatever. But if someone was pregnant or vice versa, they didn't have the accommodation. So we want to just push to a favored nation. So obviously this next slide is a little ambiguous, but questions, anybody?
All right. Well, thank you for listening. And if you have any questions, let us know on the Google
Shoot us
Drive.
Trello. Shoot us a Trello.
Trello.